30s. I wrote on Sarah Palin did it a couple of years ago, filed an application. I wrote a blog on that one. It's possible, but in terms of our trademarks, there's a sliding scale, and it goes from fanciful to generic. And the most common thing I see is for a business owner or an entrepreneur to want to describe their goods and services. So they'd want to go, dog washing, which is the worst trademark there is. You're never going to get that, as opposed to a fanciful mark like Vroof, which doesn't exist in the English language other than to be your source indicator. And those are the best ones, which is why Kodak is a great one. Apple Computers, because Apple has nothing to do with computers. And so when I have people calling me and saying, well, I'm thinking of saying, dirty dog washing, do you think that's a good trademark? No, I think that's a terrible trademark. Let's find something a little bit more unique, because it has more likelihood of passing muster under PTO scrutiny, and it also serves as a better indicator for your mark, if you can find something that doesn't have any other meaning in the world other than your business.
Okay, so it can't be generic is really what you're saying. It has to be unique. Okay.
Yeah, I have a dog washing example. If you want me to go through the scale, if you think that would help.
Yes, please. Let's do it.
Sure. Okay. Our fanciful mark, which has no meaning in the English language other than to specify your dog washing machine, would be Vroof dog groomers, right? Mm-hmm. And so then the next one down the list is our arbitrary one, where it doesn't have any kind of rational connection. So that would be big rubber ball dog groomers. Suggestive marks kind of hint at the goods or services, but don't actually say what they are, which would be something like Muddy Paws dog grooming. And then we've got descriptive, which is dirty dog groomers, which are very, very difficult to get. And then your generic would be dog groomers, impossible to get. You will never, ever, ever be able to trademark dog groomer brand dog groomers, right? So it kind of helps you in terms of when you're thinking of names for your machine or your business to think of blank brand, whatever your business is, be it dog washing machine or computer or pen or marketing service, saying, okay, what brand marketing services? And that can kind of help you get out of the generic and the descriptive world. If you're saying, well, marketing services, brand marketing services, that doesn't really make much sense. And that can kind of help you get something a little bit more fun and a little bit more unique to your business.
Okay. I see on products an R with a circle and a TM. Can you help us to understand what the differences are with them and when can we use them?
Sure. R in a circle means you actually have federally registered rights, which means you've gotten a fancy piece of paper with a gold sticker on it from the trademark office saying that you are now a registered trademark. Once you have that, you can put the R in the circle after your name. Until then, that's what the TM is for. That means that you are telling the world, you're putting the world on notice, you have a trademark in something, it's just not registered yet. You could have filed the application, or you're going to file the application, or you may want to do that later. But that's the difference. Don't use that R in a circle unless you actually have registered rights. That's very important.
So when I come up with a really cool name for a product, I have some cool names, I'm excited. I put a TM on it, so I put people on notice if I'm putting it on sales sheets or making some packaging up. When I start to use it in commerce, actively selling it to the public, that's when I notify the trademark office that I'm in business, and then I ask them to convert it. I tell them I'm using it in commerce on this particular date, and please, I'd like to move forward with registering my mark, and that's when I wait for my gold sticker.
Sure. Well, also remember, you can file what's called an intent to use application, and that is you're technically not using the mark in commerce yet, but you're gonna very soon. You can go ahead and file that application. It will be examined under your regular trademark process, and then once you get a notice of allowance, you'll have 6 months to provide sufficient proof to the trademark office that you are actually using that. And it usually comes in terms of a picture of your goods or a screen cap of the website or whatever it is you need to do to show them, yes, look, here is my goods, I'm using them in interstate commerce, so please can my certificate issue.
Perfect.
So you don't actually have to wait until you actually sell it. You can file that kind of application.
Perfect. So when I come up with the name, that's what I do. I file an intent to use. I put a TM on my material. I keep going, and then when I start to have it in use, I convert it and say that I'm using it, and then I get the registration. That's the only time I could get the registration. Put an R with a circle on my product.
Perfect. You got it.
Excellent. Okay. Beth, what else do you think, because you're dealing with inventors, entrepreneurs, business people all day long, what other topics can you share with us for the next few minutes that we have left on just really getting the information out to us?
Right. Well, I think what would be important is to kind of discuss some of the things I see a lot that can really kind of land you in hot water. And for those, and this is coming for a lot of my do-it-yourselfers and our self-help folks, is their misunderstanding parity in trademark and your fair use exemption in copyright. Those are the biggies right now. I'm seeing a lot of people who will want to make a kind of like a goof on a famous trademark and use that as a source indicator. And there is such a thing as a parity defense in trademark, but it's tricky, it's difficult, and so before you want to do something clever with another person's mark, please call a lawyer first and make sure you're not going to get a nasty gram. Okay. And then with copyright, and this is more important, is that one of the things I'm seeing a lot of is there's people thinking that there's a 30% of a work is okay to use without permission, and it comes from a really antiquated old case law. There is a fair use exemption to copyright, but giving credit to the source that you took it from will not get you out of an infringement analysis. Putting it, taking just a small bit of it may or may not, it depends, but a good rule of thumb, especially when you're coming up with a website, is just don't copy and paste anywhere. That's called copyright infringement, and you can get in really big trouble for it. So one of a good rule of thumb is, when in doubt, ask permission. Resist the Control-C button. We don't want to do that. And just a general misunderstanding of Internet issues and how they play into your marketing as well as your intellectual property portfolio, and how to make sure that you leverage all three properly and effectively. Rights by themselves don't grant you anything other than a fancy piece of paper in a frame. You've got to use them properly if you want to make money off of them. And presumably, we're inventors and we're entrepreneurs and we're business owners because we want to be the next greatest thing. Using your intellectual property to help you along the way is one of the things just to think about, and don't be scared to call a lawyer and ask. That's the best advice I can give.
That's great. What sort of information can you tell inventors and business people? And really, when you come up with an idea, we always say this on the show, Beth, you're really in business because you're going to be putting in your time, money, energy, resources, business plan. Doesn't matter. It's when you come up with that idea, you have to treat it like a business and go through. And if you have an opportunity, I mean, this is only my opinion, but if you do have an opportunity to get some sort of intellectual property rights to it, it does help. But then again, there's other types of products that are on the borderline or crossing with another product that may not necessarily get patent protection. That's when I think of a trademark. I'll come up with a good trademarkable name, and I'll also include a copyright in there, and any type of instructional material. I'll include a copyright application. Right?
Yeah, absolutely.
It's not
Perfect.
that difficult. It's just, in the beginning, Beth, for anybody, when you don't know, you're kind of naive to the whole situation. But as you start doing this and it turns into kind of a process, you turn into a machine. I come up with an idea and I do this. It gets a lot easier, and it's good to know your rights and keep up with them. So where do you think that we can kind of keep up with our understanding of rights? I mean, it's great to have an attorney like you to be able to bounce us off of, but I'd like to just kind of stay up on top of what's going on in the world of intellectual property. What do we do?
Well, a great place to start would be, the trademark office, the patent office, because they have wonderful resources. There's self-help. If you want to do it yourself, go ahead, but just do it right. Look on the trademark office and say, okay, I have no idea what this even means. Where do I go? The copyright office has a litany of publications on what is copyrightable, how to move forward with actual registration, and all of the laws that I talk about from trademark to copyright. They're all statutes, and so you can go and read those and just fire up the interwebs and say, okay, I need a federal registration for my trademark. Where am I going to go? Well, write this down. The Lanham Act is where trademarks are codified. It reads like a statute. It's really boring. So go to the trademark office instead. The Title 17 is the copyright statute. It reads like a statute. Go to the copyright office instead, and you'll find that there's just a wealth of information out there. Just be very careful on information that's not posted by lawyers or the government, because there's lots and lots and lots of people who start off with, I'm not a lawyer, but this is what I've learned as a photographer. Like, okay, stop you right there. You're a photographer. Don't be, just be leery if there's somebody who's not a lawyer lecturing on trademark or copyright or patent, and just don't be scared to educate yourself. Don't be scared to find someone that you can talk to. Some lawyers are stuffy, some are not. It just depends on what you're looking for, but don't be intimidated. You've invented the next greatest thing, so you should be fine.
Thank you, Beth. By the way, your website, do you have a website or some way for us to get in touch with you?
I do, and my website is currently under construction, and it's a hot mess, so have a heart. But it's www.hutchins.law.pro, and you can also find me on Twitter @HutchinsLaw, and you can also email me at beth@hutchins.law.pro.
Okay, are we going to see a C with a circle on after every paragraph of your website when it's out?
No, I haven't even looked to see if I have one down there or not yet. So, but here's an incidental thing: publication, the little notice, the little C, not required for copyright protection. It's a good idea to have it on your website, but it is not a bar to any kind of remedy for infringement.
And the date also. People put always change the date
copyright
to keep it
2013 Hutchins Law. Yeah, not required. Good idea, but it's not a make or break thing.
Okay,
so
it just
another
looks nice.
Misconception. There you go.
Vanity.
And we got to keep you on your toes. It keeps me in business if we keep changing the rules and making it weird. So,
Beth, one final take from you, if you don't mind. Just give the inventors out there, no matter what stage they're at. You see people all day long. There's inventors that are listening. Just give us some final words of wisdom for us, no matter what stage of the invention process we're in.
Well, I've seen time and time again, people just get discouraged because they think that, this thing is as old as the hills, or who am I? I'm sure somebody's already invented this idea. It's so obvious to me. And the most interesting and best inventions I've seen are the ones that come from people who always say, I almost didn't call you because I was convinced that this would not go anywhere, and this is, just something silly that it must already exist. And nothing could be further from the truth. The point is, don't be intimidated. Don't be scared. You've thought of it this far. You might as well just go a little bit further and see where it goes, and don't second guess yourself, and don't belittle it, because you would be amazed at some of the neat stuff out there that everybody says, oh, I swore this was just a piece of junk, but wow, look at me now. So keep the faith and keep at it. That's the best advice I could give to my artists, my writers, my inventors, my business owners. Work hard, stick with it.
Thank you so much. That was Beth Hutchins, intellectual property attorney, licensed in Arizona. Beth, one more time with your email address or your website.
Sure, it's Beth@hutchins.law.pro, and you can find me on Twitter at @HutchinsLaw.
Okay. Beth, thank you very much. Of course, I'd like
Thank
to
you.
thank our sponsors of Got